Wagwan. Good morning, good night. Welcome back. And if you're listening for the first time, welcome to episode 22 of The Real Situation, where we give you a taste of Jamaican politics. We're still in joint select committee mode, where the bill being proposed to reform the constitution is being reviewed. There's now been 9 meetings so far. There was January 15, which was the first, where the opposition leader read his statement, confirming that there would be no further participation until 4 questions are answered by the Prime Minister. As we know, one of those questions relates to the government's position on moving Jamaica's final court to the Caribbean Court of Justice. I came across this segment maybe about a month ago now on Primetime News, TVJ, where they stated that, according to a Don Anderson poll, more Jamaicans are in support of a recommendation to tie Jamaica's transition to a republic to adoption of the Caribbean Court of Justice as the nation's final appellate court, as opposed to pursuing them both separately. The question was posed. Some people say Jamaica should become a republic first and then adopt the CCJ afterwards. Others say the two should be done together. Which of these is closer to your own view? 25%. 25% said that both should be done together. 16% said to only go to a republic first. 46% are not sure or don't have an opinion. 13% have no opinion and don't care. The poll was taken from January 29 to February 13 and involved 1,200 Jamaicans aged 18 and over. And there was a margin of error of 3%. So the newscaster asked the reporter, since the party lines are drawn, on this matter, was there any political influence on the decision that was made? And the polls found that the views were not affected by any political party leaning. It was also said that in the first poll in 2012, more than half Jamaicans said that the monarchy should be abandoned, and that number was as high as 57% in 2020. So carrying on with these joint select committee meetings, January 22nd was when a presentation on the bill was given, featuring an overview of the main clauses. January 29, there was a presentation regarding the parliamentary cabinet system. February 6, presentation regarding citizenship. February 19, there was a presentation by the Ministry of National Security that addressed clauses 7 through 10 and the subject of citizenship in the Commonwealth. February 26 and March 12, the topic was the office of the President. March 19, the topic was Parliament and expansion of the Senate, and March 26 discussed submissions that were made by the public. And I must apologise for the noises around me. Mid on the road. It's a really nice day, so I'm out recording today. I'm not stuck indoors. All right, so before we get to the review of the meeting, I came across an article, Jamaica Takes Constitutional Reform to the Streets. It was in Caribbean Today on March 28th, and it was an interview with the Permanent Secretary, Wayne Robertson. And I'm just going to summarise parts of it. He basically said how they were now going into the towns across Jamaica and in the nooks and crannies of Jamaica to engage the man in the street. And they were taking a more granular approach. He did say that, they're not departing from the other engagements. They are continuing with those and have completed 6 town hall meetings in 6 parishes. We're not finished, but we've gone through Jamaica to educate and to engage Jamaicans on the Constitution and the bill in particular that is before the House. I must say, that's still really not a good enough number. 6, there's 14 parishes, so 6 town halls is coming up short. The permanent secretary went on to say, blah. I'm not saying that we've reached every single Jamaican, but we've been deliberate in engaging all sectors. Another thing that he did say is that the ministry is working towards launching a Jamaica Legal Information Portal by April, which will allow Jamaicans to access laws and legal literature in one space, which is great for legal entities. That's a great move. Okay, so now we move to a review of the March 19 Joint Select Committee meeting, right? The topic was Parliament and the expansion of the Senate. We're going to jump through it a lot. There was a lot of information, but I will attach a link to this meeting and the March 26 meeting on the podcast page. So it started out with a reading of, there was a reading of Clause 15, which proposes that the Parliament of Jamaica consists of the President, a Senate, and a House of Representatives, removing reference to Her Majesty, or as it is right now, Cara Queen dead, His Majesty. Section 35, that proposes an increase of the Senate from 21 to 27. And there are 3... so appointed by the President in accordance with 15 on advice from the Prime Minister, 9 on advice from the Leader of the Opposition, and 3 in the President's discretion. This is what is being proposed. And those in the President's discretion are from among persons in the private sector, civil society, faith-based or community-based organisations, or other sectors of the society. And in making any appointment under this subsection, the President may have regard to the representation of interests of Jamaicans who reside abroad. So Ms. Malahoo Ford brought attention to the fact that diasporans had been asking for a senator, to which she responded that you can't make policies and laws for people in circumstances where you're not prepared to abide by them and live under them. I have no idea what that statement means, but I'm quite sure that it doesn't rank in the top 30 reasons of why people leave Jamaica. She did go on to say the policy is to partner with Jamaicans at home and abroad in the best interest of the nation. Senator Golding Campbell was asking about the rationale behind the numbers being proposed, and also what's the definition of the private sector and who is civil society. She's opposed to the term being introduced into the Constitution. She said, I'm not sure what it is, if it's a voluntary organisation operating in Jamaica. She's highly concerned if the President had the ability to appoint a member from this civil society group whose interests were directed or influenced by a group outside Jamaica. She said the rationale behind categories chosen. She wanted to know the rationale behind the categories chosen. And the same point she had with faith-based and community-based. And she hopes that faith-based operates and is constituted in Jamaica with local members. She went on to say that civil societies become synonymous with certain groups, and that any group can form on any mandate and be a part of civil society. There's no real criteria. The CPC, Miss Parliamentary Council, said so far it's not been defined in the Constitution or in the bill, and the terms would have their ordinary meaning. So Private sector would mean business outside of government business. Civil society would mean any group other than a private sector or government group. And there is the possibility is open to other members of society, so listing these groups is just merely to provide guidance. One of the technical team referenced the composition of the Senate in a couple of other jurisdictions. In Trinidad, the president appoints 9 at their discretion from outstanding persons from economic, social, or community organisations or other major fields of endeavour. Barbados, 7 are appointed at her discretion to represent religious, economic, or social interests, others as deemed should be represented, which Miss Golding, Senator Golding Campbell, said she liked, as to specifically referencing, a particular group. Moving on, Clause 20, which is Section 40 of the Constitution, proposes a disqualification of an elector for the Senate or the House of Representatives serving a sentence of imprisonment or exceeding 6 months, even if the sentence is suspended and whether the conviction is in Jamaica or elsewhere. Ms. Malahoo Fort mentioned that the custodial versus custodial issue, there's controversy under the current sentencing guidelines as to whether a suspended sentence is viewed as non-custodial. So, it's an opportunity to have the matter clarified. And she also brought attention to the fact that there's a new inclusion for crimes of fraud or violence. Fraud and violence. Clause 21, which is Section 21, basically deletes the word Commonwealth and inserts Jamaican. So if you cease to become a citizen of Jamaica, your seat becomes vacant, right? Blah, blah, blah. The main focus of that is the existing provision, right? Adherence to any foreign power or state. While that hasn't changed, it does really confirm that dual citizenship is permitted, right, under certain circumstances. So you can be born in the UK, right, and have Jamaican citizenship by descent. And as long as you meet the other requirements, you can sit in the parliament, right? If you're born in Jamaica, you can acquire citizenship by descent if one of your parents was born somewhere else, right? Unless you're the leader of the opposition or the Prime Minister, in which case you'd have to renounce those citizenships unless you were born elsewhere personally and acquired citizenship by descent. Clause 22 references Section 49. We're actually going to buck up on that a little bit later. Attorney General Mr. Austin from the Attorney General's office was asked to give an opinion on on Clause 22, but he didn't speak. It was mentioned, but just didn't happen. What I would like to see actually is more input from constitutional experts. I would like to see more input. They seem pretty quiet on this whole constitutional reform, and it may well be that I'm actually looking in the wrong place for their input, but I don't see any. So, but Ms. Malahoo Fort did say, I'm sorry, there's somebody having a conversation like where I am, but as I said, I'm outside, so just allow me. What's being proposed? The bill must be proposed. Any amendments to Section 49 should be proposed in the House of Representatives. Even if an amendment is being proposed to the least protected parts of the Constitution, the amendment cannot be taken and tabled in a single day. She goes on to say that it must be done deliberately, and allow for time for parliamentarians to read and digest the bill. And so for a bill, for an act that alters any provision other than the entrenched provisions, it shall not be submitted for assent unless a period of 14 days has elapsed between the introduction of the bill in the House and commencement of debate of the whole text of the bill, and a further 14 days has elapsed between the conclusion of the debate and the passing of the bill. So you can do them one day business, right? But right now, that doesn't exist. So, moving on. Section 60. This is actually discussed in the next meeting, March 26th, so we're going to come back to it, but it talks about how a bill shall not become law until the President has assented to it and signed it. Section 64, which amends the Constitution to extend the period of to extend the life of the Parliament. All I'm going to say about that right now is alarming. That is it. Okay, moving on. So then we would actually move on to March 26, which is a review of the submissions. I'm going to backtrack a little bit and just conclude the March 19 meeting by saying that the government gave their position on the naming of groups. One grouping of Maroons are asking to be named in the Constitution. Tainos are also asking to be referenced. Ms. Malahoo Fort said, and I'm quoting, "I have to say, Jamaica is a unitary state and it is not intended to create a state within a state. This is meant as no disrespect to the Accompong Maroons, but there is a single state and we're moving to one republic out of many, one people, one republic, one Jamaica. That is the road we are on, coexisting and respectful of differences that we bring. There will be no sovereign state of anywhere else but the state of Jamaica." So that's the government's position regarding the naming of specific groups. Moving on to March 26th and a review of the submissions. So again, we're going to jump around a little bit because there was a lot of information. Clause 8 repeals and replaces sections 9 and 10, which is the provision of citizenship. Ms. Mills of the technical team read a recommendation from the Mona faculty. To align with international human rights obligations, should there be an explicit provision stating that no person should be deprived of Jamaican citizenship if it would render them stateless? An additional question about whether citizenship by descent should be clarified, if there should be a definition limiting citizenship by descent. Ms. Malahoo Fort asked for sight of the 1961 Convention on Statelessness, and said the issue of deprivation of Jamaican citizenship arises controversially in cases where someone is invoking an entitlement to Jamaican citizenship, in circumstances where that person has another citizenship and is facing deportation. That is the real problem case for Jamaica. Because the Constitution allows for citizenship by descent, we've seen cases where, though entitled, that citizenship hasn't... Okay, basically, let me just summarize it. What she's basically saying is you have people who, it's not until they're going to be deported that they want to then invoke their Jamaican citizenship. And what she's basically saying is that if the only time you're going to invoke Jamaican citizenship is when you're going to be deported, is it really in Jamaica's interest to take you? Right? That's what it boils down to. And the question then is, should the state be given the power to make an assessment and determine what is in the best interest of Jamaica in that case? Ms. Mills stated that regarding the Convention on the Reduction of Statelessness, Jamaica had entered into a reservation stating that we were not accepting the obligation to expressly state that in our legislation. Under Article 8, it retains the right to deprive a person of his or her nationality in the circumstances outlined in paragraph 3 of that article. Paragraph 3 of the article contains the obligation to expressly state that the contracting state would not render the party stateless. So Jamaica has reserved that right. So basically the question is whether in specific cases there should be power to reserve, reserved to deprive someone who would otherwise be entitled to Jamaican citizenship of that entitlement where the risks and burdens would outweigh the benefits. I find it kind of, I'd like to know, I would be interested to know what percentage of deportees are not born in Jamaica, right? And invoke their Jamaican citizenship in order to be deported to Jamaica. And why, if Jamaica already has that reservation under Article 8, why the deprivation of citizenship expressly has to be in the Constitution. And on a side note, we all know that citizen or not, sometimes you end up in Jamaica anyway, right? You don't get a chance to invoke that citizenship. So, and, you know, I was doing some research on the United States, and yeah, you can have your US citizenship snatched too in cases of, national security or terrorism. There are existing cases, war crimes and human rights violations, sex offenders, fraudsters and other criminals can get their US citizenship revoked. So, Ms. Malahoo Fort went on to say that if the recommendation being made is to reserve the power to deprive one of Jamaican citizenship, then the Constitution provision itself would have to be reworded differently, because right now it's wide open and it says that if you acquire citizenship by birth, marriage or descent, you cannot be deprived of it under this current Constitution. So then the Act of Parliament could not prescribe anything that would restrict that right. So that section, if the recommendation is being made and accepted, would have to be, it would have to make it subject to the Parliament's power to prescribe the details. A technical team member, Mr. Cross, said that from his reading, in order to make any change to allow Parliament to make changes with respect to dissent, they would have to amend that section 3C, which doesn't allow any latitude as long as that provision remains intact. So they wouldn't be able to go any further. Ms. Mills read a recommendation regarding Clause 10, which says Jamaicans hold dual or multiple citizenships, particularly in the US, the UK, Canada, and the CARICOM states. The law should specify whether renunciation of Jamaican citizenship automatically affects Jamaican-born persons who later seek to reclaim it. There should be a clear reacquisition process for former Jamaicans who wish to regain their citizenship. So that was also, brought in as something that needs to be looked into, right? Not only the power of Parliament revoking citizenship, but also people who have, renounced it, the ability to get it back. Miss Malahoo Ford did make a statement, actually, saying that every time a Jamaican commits an offence overseas and is convicted or is caught in illicit run-ins, the entire nation is punished for that. That is what caused travel restrictions to be imposed on Jamaica, visa restrictions on the whole nation, because of the acts of a small number of people. I think that was a little bit mixed up, because it's actually crimes in Jamaica that are referenced on any travel advisories. It's not anything Jamaicans are doing abroad. It's it's crime within Jamaica that was on the travel advisory. So I just thought that maybe was, maybe she got that mixed up. What she did say, though, is there are two big issues and goals. Number one, putting the Jamaican Constitution in its proper form for a supreme law. And number two, transitioning from a constitutional monarchy, replacing the monarch as a head of state with a president. And also to make the alteration provision less difficult to achieve the remaining reform goals. So, Mona Faculty of Law had another question. Whether it is being proposed to allow dual citizens to serve in Parliament except for the Prime Minister and the leader of the opposition. Consideration should be given to a minimal... Oh, and also consideration should be given to a minimal educational qualification for members of Parliament. So, Ms. Malahoo Ford said that the issue of educational qualification for Parliament has been an issue from the dawn of time, and enabling the ordinary man in a democracy the eligibility to serve. Given the work of the Parliament, you must be able to read and write and reason. Do you want to say that because you do not have a degree, you're not eligible for membership in the Parliament? I don't know if this is what a Jamaica like this would want. So, okay, I don't know. What is a Jamaica like this? And also, why would a high school graduation not be the minimal educational qualification for a parliamentarian? Whether it was when the school leaving age was 16 or 18. Ms. Malahoo Ford goes on to say that, okay, so the argument that Mona were making is that since everybody else is now required to stay in school at least until the sixth form, that is now until you're 18, that is what Parliament should be required to have. That should be the basic minimum. Ms. Malahoo Ford said, certainly... sorry, I just... yeah. So Ms. Malahoo Ford said, certainly we do not want to say that because somebody is championing the cause of others, they do not have the right and do not have all of what that person recognises to be important, that you don't have the right to champion that cause. I mean, you absolutely do. Listen, I've attached the job description for a parliamentarian, which is, it's even more important now that MPs earn between like 73 and 93,000 US dollars, right? There was a pay increase, right? Now parliamentarians earn between 11 and 14 million. So really the people electing the MP would need to be the ones, who... determine whether they think that person is able to undertake what's required, right? Based on their education or lack thereof. In certain circumstances, I mean, life experience could even be considered as a substitution for, that high school education. But, really, even separately, it's a very serious discussion, as to why so much of the population don't have a high school education, which would warrant a response of this nature. To be honest, I find that a little shocking. Ms. Malahoo Fort stated that there is currently a minimum qualification, which is to be able to read and write English. And that, it can be dealt with through the selection of candidates for election and ensure that people are trained. So the dual citizenship question, she says, is not a straightforward answer. She went on to say that in the same way that we have citizenship by descent, no one chooses his or her parents, and if you're born where your parents' nationality allows you to acquire it as descent, that's not something you have control over. So the framers of the Constitution provide for something that you must do by your own act, not something over which you have no control. I mean, that seems pretty straightforward to me, right? So she goes on to say, so the test of conflicted allegiance and not dual or multiple citizenship is what has been retained. It's about what you've chosen to do, because for some roles there can be no divided loyalty. No argue with that, because the US president, you're born in the US, end of story, right? Okay. So, Jamaica Lands made a submission demanding a right to recall members of Parliament. The issue of the accountability framework, Ms. Malahoo Fort is saying, is in the parliamentary cabinet system is one with which many Jamaicans are not familiar. And the weakness of a parliamentary system has been more on show. The weaknesses are more on show than the strengths. She says, for my role as Minister with subject matter responsibility, we appreciate the genuine concern about accountability in public life and private life too. We all have to spend more time as a society looking on the role of your parliamentarians. MPs are legislators and are seen as the first point of contact with government. And there's an expectation that an MP should discharge the functions of the whole of the government. So they call on you to be the Minister of Labour and Social Security, and she kind of went on. MPs are expected to do everything. So she's saying, then you get an angry constituent who may want to recall an MP because the road no fix. Is that a proper basis for recall? Or if you beg the MP to fix your roof and you don't get it? I think that excessive and unexplained absence is a batapanketch one, right? And to be honest, there's an element of constituent control here, right? It may well be that in instances where Parliament doesn't want to hold an MP accountable, their constituents will. Mr. Cross said that based off of the petition, what the recommendation is that if a petition's received, which is greater than the number of people who voted for the MP, it would count as a valid number. So if a petition is submitted from a number of voters in a constituency, where that number is greater than the number of votes received by the Member of Parliament in the most recent election, then a yes or no vote is held on whether the MP should remain in office or to remove the MP from office. It would only be signed by registered electors in that constituency, and their participation can be verified by the electoral authorities. If more persons vote yes than no, the seat is declared vacant and a by-election is held. There was actually one such petition that was held in Britain. It was called the North Antrim Recall Petition in 2018. That was the parliamentary constituency in Northern Ireland. It was the first since the procedure was introduced in 2015. It was called the Recall of MPs Act. And it was triggered when North Antrim's MP, Ian Paisley Jr., was suspended from the House of Commons for 30 days for advocating for Sri Lanka after failing to declare that its government had paid for his visits there. But basically the vote failed because 9.4 of the registered electors signed the petition, but it needed 10% to unseat him and force a by-election. So Ms. Malahoo-Fort was saying, yeah, sounds good on paper, right? But you might end up with an annual. Every year you have a by-election. Or an efficient, present and accountable MP. Maybe. But she did say that's not to say that we do not need a proper system of accountability. She went on to say that the opposition has indicated that it wishes to see a system of impeachment for parliamentarians in the Constitution. That issue is not going to go away. Does it have to be in the Constitution? Or we have to look at what is the most effective mechanism for holding parliamentarians to account. There is a bill that was proposed by Bruce Golding of the JLP back in 2011, and then was revised, expanded, and tabled by Mark Golding of the PNP in 2021. So, and she goes on to think that there's a breakdown in society generally, and you only have to look at the behaviour in Parliament, which she feels is a reflection of society. One might also argue that it's poor leadership. I mean, it's certain parliamentarians, who you just kind of shake your head when you're watching it, right? Ms. Mills then referenced how several groups had proposed a directly elected Senate, arguing for a required for proportional representation in the Senate, as well as participation by the people in selecting senators. And going on to say that the president should not be allowed to appoint any members of the Senate because there is a high risk of political influence. The question also asked, would 3 independent senators vote on a newly nominated president? And if not, how many would count as an absolute majority of the Senate? There's a whole bunch of questions, right? Whole bunch. Ms. Malahoo-Fort said that in the Jamaican context, the Senate was assigned a specific role. Guardian of the entrenched provisions of the Constitution. It comes with the requirement of at least one senator from the opposition benches voting with the government to make changes to the entrenched provisions of the Constitution. She goes on to say that an unelected Senate came about not only because it was modelled on the UK system, but because there were people who were willing to serve but don't wish to go through the election process. We have to consider whether there remains a proper place for that in Jamaica as we seek to respond for the call of an elected Senate, says Ms. Malahoo-Fort. A little history about the Senate, right? The Senate is actually the direct successor of a pre-independence body that was called the Legislative Council. And the Legislative Council was dominated by and represented the interests of the planter class, right? The plantation owners. In 1920, for example, 9 of 14 candidates for Legislative Council were returned unopposed, right? Dominated by the white planter class, and led by R.F. Williams and F.M. Kerr Jarrett, two of the biggest banana planters in Jamaica. So that's a little bit of history on the Senate. In the 1960s, the second chamber was created by Norman Manley and Alexander Bustamante. They were originally opposed to it in the 50s, but agreed to add that second chamber and called it the Senate. And they felt there was good reason to, because the colonial representatives would be removed and the Senate would be made up of Jamaicans nominated by the Prime Minister and leader of the opposition. Its members would be appointed, not elected, but there was value in this. By a fixed formula, the opposition would have a baseline membership with enough members to block unilateral constitutional changes of fundamental importance. The power was critical to having the constitutional bipartisan system needed to check excessive executive power in one-party governments. A Senate would give the executive a wider pool from which to draw ministers with skills that weren't available in the lower house. Parties were criticised for appointing persons who had failed to win the confidence of the voters at the polls, and basically allowing them in through the back door of the Senate. Another criticism is that the Senate's become, an extension of the political divide in the lower house. And Ms. Malahoo Fort said, we have to appreciate that, these are genuine concerns, right, about the Senate. She did say that a directly elected Senate will present an injustice to the principle that we are reserving a place to have suitably qualified Jamaicans serve without going through the rigors of an election. That just smacks of so much political aristocracy, though, right? Right. She went on to say that, sorry, I lost my place, but basically she made a statement basically saying, here it is. So, I put it in the wrong, thing, but it's okay. I color code some of the stuff that I'm looking at. It was color coded wrong. So she went on to say, regarding disproportionate representation, do you want an opposition who's going to stand in the way, or a government that will responsibly discharge its functions and get things done in the interest of the people? But what is the opposition? The opposition is useful and necessary, right? They're a component of democracy, especially in ensuring that there is a transparent and accountable government that serves the people's interest. We need the opposition, right? We need the opposition. The role of the official opposition is to question and scrutinise the work of the government. We need them. Ms. Malahoo Fort was on a roll. She went on to say, she was speaking to Ms. Mills, one of the technical team, and she said, they want the people to elect and determine, and I'm quoting Ms. Malahoo Fort, they want the people to elect and determine who should go in the Senate. But in effect, That is what happens. When you give the power to a prime minister to make recommendation, and you give the power to a leader of the opposition to make recommendation, that is the end result. Because those people are elected, and they are elected on behalf of others, and they command the confidence of many others. So asking for things that already exist just because we don't understand or make the connection between our ask and what's in place. So what she's saying is you really elect a senator because you voted for the party who selected the party leaders who became the prime minister and the opposition leader, and they in turn appoint the senator. Wow. I'm going to leave that one right there. Okay, pressing on. Clause 26. Ms. Golding Campbell was talking about the submission. She said it poses an issue as the president would be unable to prevent a bill that is in violation with the Constitution from eventually being assented to. A provision could be included outlining that a head of state could only withhold assent where he or she reasonably believes that the bill, if it were to become law, would be ultra vires, exceed its authority with the Constitution. So the question then is that whether the president should be empowered to refer the situation to the Supreme Court for a ruling on its constitutional validity before assent. Ms. Malahoo Fort referred to the president's role in that respect as a token role because laws are really passed by the parliament. I can't agree. I can't say I agree with that term token because, brethren have all heap of power. But basically, if the president does not give assent, the bill doesn't become law. And then she asked the CPC to explain how a bill does become law. They confirmed that the next meeting will be... Actually, they confirmed that there's going to be a CRC meeting, that there was going to be a CRC meeting that same day, but reinforced the fact that the Joint Select Committee takes priority at this stage. And the next meeting will be on April 2. I'm actually going to leave you with more words of Ms. Malahoo Fort. The constitutional reform is a time of reckoning, as it has brought to the surface a number of issues and a number of things that have been bubbling and boiling below the surface. And it's providing us with an opportunity to relay the foundations and to rebuild them. The government is serious about reforming government and our laws to achieve our goals and aspirations and create and reignite national pride in who we are as a people and who we can be. To mainstream excellence in our culture instead of having pockets of excellence. To have solid institutions run by people who have integrity and understand accountability. It's all about serving the people in a better way. It's not just talk. Denzel Washington says you can't legislate love, but what you can legislate is accountability and integrity. The Constitution can be amended to give Parliament the power to impeach members of Parliament, and that will really show seriousness, real seriousness, about reforming government. There's a bill called an Act to amend the Constitution of Jamaica in order to provide for the impeachment of senators and members of Parliament sitting ready and waiting. If you're not registered to vote, Today was the last day, March 31. Yep, that was the deadline to register for the next voters list, which is scheduled to be published on May 31, 2025. I hope you're continuing to enjoy the journey, finding it educational, useful and ting. The next Joint Select Committee meeting is Wednesday, April 2, so our travels on the road to Jamaica becoming a republic will continue. This road can't be patched, though. It needs to be totally torn up and laid down proper with drainage and all of them thing there, right? Because it needs to last a long time. Still confident this journey will end with a truly independent and sovereign Jamaica, land we love? How you mean? You can find this podcast on YouTube, Buzzsprout, Spotify, Podcast Index, Deezer, Podcast Addict, iHeartRadio, and Amazon Music. If you want to reason about anything, or if you can't find any of the material I was talking about, you can email me on atasteofja@outlook.com. Until the next time, thank you for supporting this podcast. Please subscribe, follow, and share it with friends and family. Like up the thing, man. And again, I thank you for taking the time to listen. One love. Yes, the word is love.